Please be seated. The court is now in session. Before I hand the floor to Khieu Samphan's defense to present their closing statements in case 002/01, the greffier, Mr. Dojpari, please report the attendance of the parties and individuals to today's proceeding. Dojpari. Good morning, Mr. President. For today's proceeding, all parties to this case are present. On a side note, Noonji is present in the holding cell downstairs, pursuant to the decision of the trial chamber concerning his health. Thank you. President, thank you, Mr. Pari. And now the chamber would like to give the floor to Khieu Samphan's defense to present their closing statements. You may proceed.
Thank you, Mr. President. I am therefore going to start these final statements for Khieu Samphan. And as an introduction, I would like to explain to you in a few words the philosophy behind our statement. We have attempted to develop our substantive arguments in the closing brief, which we filed a few days ago, and within the limit of the 125 pages that you imposed upon us. Over the past 2 days, my colleagues, Mr. Victor Koppe and son Arun, pleaded with great precision numerous points that our team and theirs elaborated in our briefs. And given the great quality of their statement, it did not seem necessary to us, or even appropriate, to revisit all of the points each time they brought them up. And in order to say things clearly, we would like you to consider that everything that they stated with much talent before this chamber is accepted by us and supported by us in the Khieu Samphan defense. I would like now to begin with a question which was already part of the introduction of our final brief, and that regards the scope of the trial. And I will finish by bringing up the issues of evidence before giving the floor to my colleague Anta Gise and our colleague Kong Sam-on will finish this first day. The trial that is organized here is such that when we drafted our closing brief, we did not yet know the terms developed in the final brief by the prosecutors. Indeed, both of their final briefs were filed on the same day, practically at the same hour. That is to say, 26 September 2013. But, however, this issue of the scope of the trial is even more so important when we discover the way that the prosecutors have changed in their closing brief and in their oral statements, their factual argumentation and their legal argumentation as well. And in order to be understood properly, and I'm speaking about the public essentially because as you all know exactly what I'm going to be speaking about, I would like to remind you of a few key dates. On 15 September 2010, the investigating judges who had undertaken the investigation regarding Pieux Sampon in particular issued a closing order covering the totality of the facts that allegedly were committed in Cambodia between 17 April 1975 and 6 January 1979. This closing order mentioned, and your court was seized of, many, many crimes, alleged crimes, I should say, that were committed under the aegis of 5 policies of democratic Kampuchea. These 5 policies were, first of all, 3 population movements, first of all from the cities to the countryside, and then within the countryside itself, from provinces to provinces. 2, the implementation and the operation of cooperatives and of work sites. 3, the re-education of new elements, the slaughter of enemies within as well as outside of the ranks of the party. 4, the targeting not only of former soldiers and officials of the Khmer Republic, but also of Cham, Buddhists, and Vietnamese. And 5, the regulation of marriage. This is the global picture of the closing order. On 22 September 2011, whereas this trial had not yet started, your chamber decided that in the interest of a proper conduct of the proceedings, you should not try in one go all of these facts. And therefore, through a severance order dated 22 September 2011, you selected certain facts that you were seized of by the closing order I just spoke of, and you considered that these facts should be the object of this first mini-trial. And you announced back then, without providing any further clarification, that the other facts would be tried later on in further trials that would be organized after the first. At the beginning, the facts that you selected through your decision of 22 September 2011 were limited to the 2 population movements. There were 3 in the closing order, but you decided that the first trial would only be focused on 2 of these movements, the evacuation of Phnom Penh and a certain number of other population movements that started as of August 1975. Then, on 8 October 2012, through a decision E163/5, whereas our trial had already started 11 months earlier, 11 months and 13 days to be precise. So we were here before the chamber for practically a year, and you decided, and I quote, free translation, to rule once and for all which would be the categories of facts and other issues that will finally become the object of the first mini-trial in case 002, end of quote. And that day, your chamber took a decision to extend the severance that it had already had decided on 22 September 2011. And that day, you decided that beyond focusing on the population movements phases 1 and 2, the current trial would also involve the events that occurred at Tulpul Tray in the few days that followed the evacuation of Phnom Penh. And I'm insisting upon the fact that this addition was limited to Tulpul Tray and its operations during a few days in April 1975. And you also say clearly in your decision, it was the immediate operations after the evacuation of Phnom Penh that mattered to you. In fact, that was the way that you managed to link Tulpul Tray to the trial that already involved the evacuation of Phnom Penh by saying that we could consider that the events were connected. And I'd like also to insist upon this because Tulpul Tray is an execution site which, if we read the closing order, apparently continued operating later on. In 1976 and 1977, in your decision of 8 October 2012 is very clear. Your decision to include Tulpul Tray only involved the operations of this site immediately after the evacuation of Phnom Penh, and you also insisted on the fact that this is an addition that would not have many, many consequences in terms of how the trial is organized, because this addition would only mean that 2 extra witnesses would have to come to testify before your chamber. And with this decision of 8 October 2012, you passed on a key document to us, which you entitled yourselves as a definite list of all of the paragraphs in the closing order of 15 September 2010, which constitute officially the framework of our trial today, the trial in which we are expected to plead today. And you were right in saying that this decision was an official act. In fact, it's even more than that. It is the founding document of today's trial. This document, you are seized of this document in personam and in rem. That is to say, that you are seized of the people and of the facts that may be tried during this trial. The facts that are not covered in your severance order, which includes Tulpul Tray now, therefore cannot be tried. They were not the object of the 2 years of proceedings that have just passed. It is as simple as that. It is as demanding as that. It is a basic rule. And by the way, during the 2 years that have just passed, 2 years of hearings, each time that a witness dared to bring up facts outside of the 2 population movements, and as of October 2012, when you added Tulpul Tray, also therefore facts that are outside of this predefined scope, your chamber interrupted this witness or interrupted the lawyers who were speaking about other topics. And if we assess what has happened, the only people who were authorized to step out of the scope that was defined that is, say, Population Movement 1 and 2, Tulpul Shrey, were, first of all, the civil parties, when the civil parties were speaking about their suffering. And that is, of course, normal, because it would have been a bit inappropriate to ask the complainants to make a distinction between the causes of their suffering based on the policies that might have been at the root cause of this suffering. That would have been a bit clumsy, and that would have been a bit untactful. The other people who also were authorized to speak about the totality of the closing order are very elderly witnesses. For example, we have Sakim Lumut, Long Noreen, for example, who could not even move, and that we had to hear through the video link. As you remember, this is this gentleman who was heard when there was a marriage right next door to where he was testifying. And we also were hearing music at the same time as his testimony, if you remember. So therefore, for practical reasons, because of the great age of the witnesses, we indeed allowed this witness to testify on the totality of the scope of this trial. And it is a bit for the same reasons, coupled with logistical issues, that both experts, Chandler and Short, were able to bring up facts going beyond the population movements 1 and 2 and Tulpul Shrey. Or even the policies that encompass them. We may be surprised that the scope of the trial varies in this way in October 2012, whereas the trial had started 11 months earlier. But I would like to remind you that Monsieur Cusempon did not lodge an appeal. Not only an appeal against your initial decision to sever the closing order, but also against this decision 11 months after the beginning of the trial, that is to say, to include Tulpul Shrey. We believe that the rules were stable and that the rules would be respected, and that the acquittal would be quicker, let's say things frankly. And beyond these two decisions of September 2011 and October 2012, your trial is not allowed to restrict the scope of the facts it is seized of. You are free to characterize legally the facts as you wish at the end of the trial, under the condition, of course, that you have offered the defense the possibility of expressing itself on a possible legal recharacterization. And when I'm speaking about legal characterization, I'm speaking about the way that we dress up a fact, the category in which we place this fact, not the fact itself. Indeed, a trial is, first of all, the fact. The fact is the root of the entire story. It is the action. It is the founding event. Whereas the legal characterization may fluctuate until the end, as long as the accused has had the possibility of defending himself. The fact that is tried cannot change unless you violate all of the principles of a fair trial. So I would like to cover quickly this definite list of the facts that was given to us in October 2012 after your decision to broaden the scope of the trial to Tulpul Shrey. So I will go over the 7 major parts of this document that you may display on the screen if you allow me to do so. There are 4 pages. It's going to go quite quickly. The first part, the factual presentation. In fact, your document covers covers more or less the structure of the closing order. It selects the certain paragraphs from the closing order. So, presentation of the facts. We have a historical text of the advent of the regime of Democratic Cambodia, the administrative organization, the central decision-making bodies, the administrative structures at the local level. Then we also have the communication systems. We have the military organization. And then we arrive at two chapters in this first part that are not that interesting, maybe. The facts linked to the joint criminal enterprise, a few paragraphs. It's only basically an introduction. And the last part, the policies implemented in order to achieve this common project. Population movements, and here it is stated that only phases 1 and 2 will be considered. And the measures directed towards specific groups. And here it says that we will only concern ourselves with the measures targeted against the soldiers of the Khmer Republic at Tulpulshrey. It's very clear, isn't it? There is no room for the slightest doubt. And part 2, facts related to the alleged crimes. This here is the examination of the underlying crimes, the crimes that are liable to be characterized later on as crimes against humanity. And we find the same logic here. Population movement, phases 1, population movement, phase 2, execution sites, Tulpulshrey. Now, let me pass on to the second page. Part 3, the role of the accused. C, que s'en-pense. And it is stated here that during this trial, the context will be examined, and the fact that he was a member of the Central Committee and that he participated in the work of the Standing Committee, that he was the president of the State Presidium, that he was a leading cadre in Office 870, that he was in charge of commerce and of price lists, that he had other roles, possibly that he had relations with other high leaders of the CPK, and then we are told at the very end, regarding que s'en-pense, participation in the common project, population movement, and it says that the consideration will be limited to phases 1 and 2 and measures targeted against specific groups, and the consideration will be limited to the soldiers and officials of the Khmer Republic. It is also quite clear, isn't it? And when we speak about participation to a common project, the facts considered, the facts that you are seized of, the fact that we are expected to defend ourselves with are strictly limited by this definite list, this definitive official and founding list. Now, let me continue. Part 4, third page. Legal findings relative to the alleged crimes. Here, the point is to know here if the underlying crimes that were treated in Part 2 may constitute crimes against humanity. And each time, the same limits are determined again. Underlying offenses that constitute crimes against humanity. Murders. Examination will only be limited to Tulpulshrey. Extermination, because sometimes there are slight distinctions, because there are facts here that que s'en-pense is not accused of having participated in regarding some of these events. But each time, extermination, and the examination will be limited to population movement phases 1 and 2 and to Tulpulshrey. Persecution for political reasons, the examination will be limited to the population movements 1 and 2 and also to Tulpulshrey. Other inhumane acts in the form of violations of human dignity, the examination will be limited to the population movements phases 1 and 2. Other inhumane acts in the form of forced transfers, the examination again will be limited to population movements 1 and 2. Other inhumane acts in the form of forced disappearances, the examination will be limited to the population movements phase 2. So things are very clear, aren't they? It is written in black and white. Now let me pass on to part 5. The modes of responsibility. Subparagraph A, responsibility resulting from the participation in a joint criminal enterprise. Paragraph 1521 to 1525 of the closing order are those being considered, and the Chamber tells us, in parenthesis, excluding everything that concerns the grave violations of the Geneva Conventions and of the involved subparagraphs, the creation and operations of cooperatives and work sites, the re-education of the bad elements, and the elimination of the enemies within as well as outside of the party, and the regulation of marriage. Excluding, and only considering the soldiers and officials of the Khmer Republic regarding the implementation of specific measures towards specific groups, in particular the Chams, the Vietnamese, Buddhist clergymen, and former Khmer Republic officials. That is what you're saying in this part. In this part that encompasses the specific measures towards specific groups, you say that you will only be focusing on the specific group of the former officials of the Khmer Republic. So things seem to be, as a little lawyer, particularly clear. B, participation in the joint criminal enterprise. I will just gloss over that. C, category of joint criminal enterprise. We'll gloss over this for the moment. We'll speak about this later. D, other modes of participation, because there's not only the joint criminal enterprise that may be invoked as a mode of responsibility in this case. There are others. Well, you mentioned them here. It is the organization, the incitement, and the aiding and abetting, and the fact of ordering, and hierarchical responsibility. And each time you say it clearly, the examination will be limited to the underlying offenses that are relevant. That is to say, offenses such as you have limited them in the preceding parts. That is to say, population movement 1 and 2, and the events that allegedly occurred at Tulpoltre in the few days that followed the evacuation of Phnom Penh.
Encore une fois.
Once again, everything appears to be clear. Everything appeared to be clear to me. Nuon Chia and Ieng Sari at the time were involved in this. According to you, they put in place the system for prosecution, so you chose paragraphs. Only one paragraph. The closing order has only 1613, and there you say that the consideration will be limited to underlying offenses, relevant crimes against humanity. This is what you defined in these parts, which I have just read out. I crave the court's indulgence for such a presentation that may look rather extremist, but that is how I work. When I do not understand something, I keep quiet, but when I understand it, I speak out. This reading shows that it is unquestionable that whenever we have to talk about the facts, whenever we have to talk about modes of liability, you limited your jurisdiction to population movement phase 1 and phase 2, and to the events at Tupotray in April 1975. I would like to very quickly describe what we are talking about before we move on. Population Movement Phase 1 and the evacuation of Phnom Penh in April 1975, according to the prosecution, was decided in June 1974, and it was very quickly implemented, and the implementation lasted only a few weeks. In reality, the majority of the population of Phnom Penh were very quickly evacuated out of the town, and the paragraphs it chose in the closing order state that the evacuation went on for several weeks. Generally speaking, one can say that the implementation of the evacuation ended in early July 1975. It is difficult to determine a specific date. We know on what date Phnom Penh was captured by the Khmer Rouge, but to know when the last inhabitant left Phnom Penh is another story regarding the number of victims who suffered as a result of the evacuation. It is not clear. We have to look at the closing order. We don't have to go into a controversy here. Some people saw bodies of soldiers still in uniform, which could have been the result of the war with the Khmer Rouge. Some people saw Khmer Rouge soldiers offering rice and shelter to the population on the move, and others they witnessed scenes that were more painful to grasp, children suffering and so on and so forth. As regards the number of victims involved, in the paragraphs we have referred to, there's talk of 2,000 to 3,000 victims, a figure given by Ieng Sari during an interview. As for Ben Kierman's and Short's own assessments, my learned friend Kope talked about this yesterday, and I'll add a few words to what he said. All what was said doesn't have any probative value. Figures are bandied about. There's a figure given by Ieng Sari for propaganda reasons, but in the closing order we have 2,000 to 3,000 victims. Regarding the massacre of Long Nor troops in Tropochet, the dates given are also fluctuating. We'll talk about that. The date is not very precise, but if we go by the broadest range given in the few statements on this, that occurred between the 15th of April and the last days of April. The assessments given are also very vague. There is talk of 200 to 2,000 victims. Let us now talk about the second phase of the population movement that concerned 400,000 to 500,000 people. It is believed to have been decided in August 1975 and implemented as of September 1975. Somewhat as in the case of the evacuation of Phnom Penh, we do not know when it stopped, because all that is very vague. Your chamber, as well as the prosecutors, by the way, in their closing statements, said that it ended in late 1976. In our own arguments, we have retained that period because we do not have any evidence to contradict what you have stated. The only remark I can make is that the Khmer Rouge evacuated Phnom Penh, that is about 2 million people in a few weeks, and we do not see why they would have needed a year and a half, that is up to late 1976, to evacuate 4 times that figure. It appears somewhat surprising. It is therefore perfectly possible that phase 2 of the population movement that was decided in 1975 occurred a lot more quickly than we have considered here. Perhaps before the end of 1975. As a matter of fact, the issue of the duration of the implementation of the decision regarding phase 2 of the population movement shouldn't pose a problem in this trial as far as Mr. Keo Sampan is concerned, if the prosecutors had not kept modifying their theory for other events, and they continue to say that our client could not have failed to know about the second population movement implementation. So they keep changing their case, changing their theory on this issue. We will talk about it. Regarding the number of victims of phase 2 of the population movement, we do not know exactly how many people were victims of it. The civil parties, as we know, stated that the conditions in this second evacuation were better than in the first. They make calculations that are out of place, dividing the number of victims in the case of Phnom Penh by 4 and then by 2 because it wasn't well organized and so on and so forth. We do not know because they do not give us the number of victims. There is no proof of the number, and we cannot retain the figures given by Professor Ben Kiernan because this figure is not credible. I have said so before, and I'll say it again today. Now, let us focus on what the prosecution said over the past few days. We will find that in two key areas of this trial, the prosecution asked the chamber to rely on facts that are outside of the scope of the trial to find Mr. Keo Sampan guilty and sentence him to life imprisonment. They do so regarding characterization of crimes against humanity, and they do so in their definition of the common purpose of joint criminal enterprise. And they ask that you adopt this characterization and to reach a finding of guilt. For non-juries listening to us in the gallery, let me point out that a crime against humanity is a common law crime, also referred to as an underlying crime. It has the specificity of having been committed in a specific context. And before this chamber, before this tribunal, in order for us to say that this underlying crime is a crime against humanity, the basic crime must have been committed as part of a systematic or widespread attack against a civilian population and on discriminatory grounds. It is this specific issue that the prosecutor analyzes in paragraphs 647 to 652 of their closing arguments. Now, what did they say in their closing brief filed some days ago? They state that the attack certainly included those population movements, phases 1 and 2, and the atrocities at Tuproche, and the unofficial translation and the fragmentary translation that we made of this document is as follows. The prosecutor, therefore, says that this attack consisted in the enslavement of the entire population in the cooperatives and on work sites, that hundreds of thousands of people were imprisoned, tortured, executed in those prisons and in other places such as the mass execution sites, such that there were 800,000 to 1.3 million dead. End of quote. we are not talking about the same trial here. In the next paragraph, the prosecutors write that the attack, which was the precondition for the characterization of the crimes as crimes against humanity, they said that the attack lasted 3 years and 8 months, and that it targeted 8 million people. In the next paragraph, the prosecutors write that among the acts of violence perpetrated during that attack, one would include, and I quote, the execution of real or imaginary enemies, the adoption of specific measures for persecution and discriminatory measures against the Cham, the Vietnamese, the Buddhists, enslavement, and the imposition of forced marriages and sexual relations. End of quote. So much as regards crimes against humanity. Let me now deal with the reasoning of the prosecution regarding joint criminal enterprise. For non-jurists listening to us, I don't know whether in the gallery we have young law students, and I want to greet you all. Joint criminal enterprise, from a legal standpoint, is the fact that at least two people agree with a view to committing one of the crimes before this tribunal. So the joint criminal enterprise is not a crime, it is the form of committing a crime. Now, what do the prosecutions write in the part of their brief regarding joint criminal enterprise? That is paragraphs 679 to 698. Well, they do exactly what they did in the paragraphs I have just referred to above. They base their reasoning on the charge that Mr. Kyo Sampan participated in a joint criminal enterprise with a view to enslaving all Cambodians between 1975 and 1979. It is not by chance. It is not at all by chance. It is because the prosecution has just developed a new thesis regarding a type of joint criminal enterprise that could be adopted in this trial. Since they filed their closing brief in September 2013, the prosecution pleads that it is the systemic form of joint criminal enterprise that is applicable in principle. Up until then, the prosecution argued that it was the application of the elementary form of joint criminal enterprise. As all the lawyers here present know, this change is part of a strategy, part of the prosecution's tactics to lower the bar as regards the proof of criminal intent. I will refer to your decision in the Deutsch case. Mr. Deutsch supervised a camp. He supervised S21, and in paragraph 509 of the Deutsch judgment, and we recall that Deutsch was convicted for the systemic form of JCE, and your chamber wrote, for the elementary form, it is important that the intention to commit this specific crime is shared by all the co-perpetrators. And it suffices to establish that the accused personally knew of the system of ill treatment and that he had the intention to contribute to the functioning of this system. And that is why for the past few days, the prosecutors pleaded that the entire country, Cambodia, became a concentration camp, a nation of slaves, and they were trying to support your severance decision, that all the policies were put in place and implemented, all the policies in the closing order of 2010. The prosecutors are not talking of a conceptual existence of policies, but they are talking about the implementation of those policies. If these policies, which are not within the scope of the trial, had remained on the drawing board of the Khmer Rouge, if they had only been in the preparatory stage, if they had only been decided but not implemented, they would not produce the legal effect that the prosecutors want to give it today. And the prosecutors cannot prove what they are asserting. In order for Cambodia to be described as a slave state, the prosecutors must prove that all the policies in the closing order had the effect of achieving this horrible result, and that they were therefore implemented, that the population movements, the cooperatives, the work sites, the re-education of the new elements, and the massacre of enemies within and outside of the party, and the targeting not only of the ex-Khmer Republic officials, but also the Cham, the Buddhists, and the Vietnamese, and the regulation of marriage. And that is exactly what they are doing. So my first question is as follows. What the prosecutors are talking of in these two parts of their closing brief, which I've just referred to, are they facts in the meaning of Article 98, Paragraph 2 of the Internal Rules, which states that the chamber can only pass judgment on facts mentioned in the closing order, end of quotes. And the answer is yes, of course, because reducing 6 to 8 million people to enslavement, sending them to cooperatives and work sites, imprisoning them, torturing them, and executing them in prisons and specialized sites, obliging them to get married and obliging them to have sexual relations are the facts. When the prosecutors talk about attacks, they argue that those attacks took place. When they talk about policies, they argue that those policies were implemented. They are dealing with facts. This is unquestionable. My second question is as follows. Are you legally seized of the population movement phase 3 of what happened in cooperatives, what happened in work sites, what happened in prisons, what happened in Tuproche after April 1975? Are you seized of what happened in other execution sites? Are you seized of discriminatory measures against the Cham, the Buddhists, the Vietnamese? Are you seized of the regulation of marriage?
Merci de me rappeler à l'ordre, Monsieur le Président.
Thank you for calling me to order, Mr. President. I crave your indulgence. I will slow down. My second question, therefore, was to find out whether you were seized of all what the prosecution is pleading in their closing brief and in their closing arguments, requesting that you should hand down the maximum sentence, persecution of the Chams, imprisonment, regulation of marriage, discriminatory measures against the Cham, the Buddhists. No, no, no. No, you are not seized by virtue of the severance that you decided all by yourselves, your honors. Nobody asked you to sever the case. I am not aware of anyone asking you to do so. We have very clearly seen a while ago with this rather extremist interpretation, but we've seen the list that defines the scope of this trial, and we find that this scope excludes all of that, and that all the legal texts were ruled out in the article, in the closing order. For instance, third question, are you legally seized of the charge of enslavement, since the prosecutor argues that the entire country was enslaved? No, you are not. This crime against humanity is expressly excluded by your selection of the paragraphs in the closing order, paragraph 1613. And this has never been the subject of debate. Fourth question, are the facts you are seized of such that they gave rise to the deaths of 800,000 to 1.3 million people? The answer is no. We have just seen that the maximum figure given, that is the figure for victims, that is 2,200 to 5,000 victims, is not something we can accept. So what is the prosecutor talking about? How can they talk of 1.3 million people in a trial in which the highest figure given does not exceed 5,000? Of course, one victim is one victim too many. But what is happening here in this courtroom? What is happening on the other side, that is on the side of the prosecution? The next question. Now, the facts you are seized of, did they go on for 3 years and 8 months? No. I talked about this when I referred to the two Prochet massacres and the Phase 2 population movement. If we take the broadest range, we have a period from April 1975 to December 1976. That is over a period of 1 year and 8 months. Ladies and gentlemen in the public gallery, I would like you to properly understand the rules regarding referral of cases before international criminal tribunals. And these rules are such that 90% of what you have heard the prosecutor plead over the past few days is off topic. Now, these rules are taught in first year programs in law faculties. So it is basic, it is elementary. It is not possible to have a fair trial unless these rules are abided by. So the question I ask is, in setting up the prosecution team, did they commit errors? Did they unwittingly hire a gang of tourists who were about to end their holidays in Cambodia, backpackers in a hotel on Riverside, who wanted to extend their stay in Cambodia and who want to make a few dollars by donning their purple robes and offering their services to the tribunal? Well, I recall that most of you are from the Anglo-Saxon system, and you are therefore lawyers disguised as prosecutors. So I can suppose, therefore, that you are ready to tell any story in any manner to win your case. Unfortunately, that is the opinion that we, the defense lawyers, are accustomed to having. Even though your first commander defected recently, you believe that you are on a commando mission, a mission which consists in obtaining a conviction at all cost. You are convinced that the entire world is focusing on you, is looking at you. When the courtroom is empty. It is because people are working behind their computer screens. You are convinced that your mission is more important than rules of law and procedure. You are wrong, counsel for the prosecution.
President, counsel, please use your words professionally, and you need to abide by the code of conduct for the counsel. Thank you. The chamber hoped your statement will not have a negative impact on other parties. So please do not direct your statement or the closing statement or presentation to any particular individual. Thank you.
Okay, I'll make sure that I do not fall into this trap, I promise you. So I was saying that under the cover of a commando mission, you are taking the risk of ridiculing a legal system that is already quite weak. You're taking the risk of drowning the only true mission that entrusted you, the United Nations, that is to say, to participate in the establishment of a strong and equitable justice. You're taking the risk of violating the public interest that you're supposed to defend and represent when you bring up facts that were never the object of this trial and whose legal characterization is also impossible because the texts that correspond have been expressly cast aside without rediscussing their re-inclusion. You're taking the risk of giving a very poor example in Cambodia that is undergoing so many difficulties, but also to the rest of the world that has commissioned you to participate in this work of justice, no matter the outcome. No matter the outcome, a sentence or an acquittal. If this trial is only focused on a sentence, then we should stop it immediately. It will be of no use, no matter the outcome. I am saying that you're taking the risk because, as the Supreme Court has just reminded us in a decision that was issued at the beginning of this week, as long as the Chamber has not sentenced or convicted on the basis of your proposal the accused, we can only speak about risks. So I must say, however, that I had a brief moment of hope when I discovered the submission that the co-prosecutors filed on 7 August 2013. It is document E284/5. A submission that the Chamber did not deem necessary to give to us, and which, therefore, we were not able to react to, and that we discovered only when the Chamber addressed this request on its own. And in this request, you, prosecutors, you begged the judges to, and I will quote again my personal translation, open quote, do not draw any conclusions, whether legally or factually, from all of the facts that are not part of the crimes selected for this current trial. And you even went so far as to write that the facts outside of the scope of the trial should not be taken into account because the defense, and you say, has not had the opportunity of confronting and of cross-examining the slightest witness on these facts. End of quote. Thank you for this. Thank you very much. Of course, we noted that you were trying to introduce, at the same time, in the scope of a trial that had already been defined, factual and legal elements that were not in it originally. But let's say that at least there was some kind of nice appearance. And given the content of your final brief, and given your pleadings over the past days, I believe that this was a last moment of conscience, maybe. Because today, we believe that we have reached the bottom. And we have reached the bottom even more so violently with this phony rhetoric that was used Monday afternoon by Ms. Chea Leang just before asking for a life sentence. And I'm speaking about this way of saying, I am not asking the court to quarter Khieu Samphan's children before him. I'm not asking the court to enslave him. I'm not asking the court to throw him on the roads without eating and without drinking, etc., etc. These statements reveal an intent. The point was not for the co-prosecutors to do a bit of literature. I don't think so. The point was to claim that Monsieur Khieu Samphan is such a monster that he is not really entitled to a trial. He should already be happy that his children are not being quartered before him after having starved them. In their introductory statements, Jacques Vergès, the late Jacques Vergès, mentioned Talleyrand, who said, "What is excessive is vain." And therefore, the submission of Ms. Chea Leang was excessive, but it was not done in vain. It is not without some kind of idea behind her mind that Ms. Chea Leang asked for the maximum sentence in this way. She was also defending her own case in front of you. Your Honors, the message, the underlying message, was that these people who are innocent, this person who is presumed innocent, is such a monster that you should not be afraid of violating the law that you created. I will take the liberty respectfully to remind you that when human societies, civilized societies, take the risk of entrusting to a human being the care of trying another human being for even very, very, very grave crimes, societies generally take a bit of caution. First of all, they choose judges on the basis of their knowledge of law, on the basis of their proven ethics, on the basis of their career. And as my colleague Kopi said, judges are not left alone. You are 5 of you on the bench to decide. And this collegiality is there to constitute a rampart against the excessive power of one single one. And you are surrounded by rules that are imposed upon you. And rules that you cannot escape from. These rules are your best allies. These rules allow you to achieve the enormous task that consists in trying events, alleged events that are so serious. Indeed, by trying to avoid proposals such as the prosecution has proposed to you, these rules are stronger than the judges. These rules are greater than you. You're not expected to modify them as in some kind of government formed by judges. These rules rule you, and these rules are your allies. But what the prosecutor is asking you with this way of asking for a life sentence is almost like trying to undertake some kind of coup d'etat against the judges. It is asking all 5 of you to consider that the rules of human society that chose you to try this case are not that important in the end. They're asking you to relieve yourself from these rules. The objective of the prosecutors is to condition you, is to relieve guilt from you in advance, and to ask you in a certain way to violate your own oaths. Do not be afraid, says the prosecutor. They are already guilty. So nobody will criticize you for a bit of tampering with the law. However, the stronger the law is, the more you and your successors will be able to make sure that this law is respected, and the stronger justice will be. Whereas, the more the law is violated, the less tomorrow's society will be a society in which justice is respected. We're speaking the prosecutors are speaking about national reconciliation around a bonfire in the middle of the court. But at what price? The price of ignoring the rules of law? We're asking you to determine that Que Sampan contributed to enslaving in all of Cambodia, whereas even enslavement is not part of the crimes against humanity that are covered in this trial. And we have never been asked to discuss these crimes. You are asked to say that there were horrible cooperatives throughout the entire country, execution sites, re-education sites, and that crimes were committed on the Chams, on the Buddhists, on the Vietnamese, that people were obliged to get married, to have sexual rapport, whereas all of these topics have never been covered before you, whereas no evidence has been presented to you on these issues. And it is in order for you to accept this deceit that you were told ceaselessly that even if he did not look into his victims in his eyes because he was hidden in a Phnom Penh, emptied of its population to take his criminal decisions, it is indeed Que Sampan. It is really Que Sampan who held the club with which the Cambodians were beaten. You were told that it was he who refused to give the grain of rice to the child. You were told that it was he who was torturing at S-101. It was he who would sentence people to death for stealing a mango. It is he who quartered children. It is he who forced people to get married. It is he who slit the throats of monks while laughing. In fact, prosecutors, the American pilots, by the way, of the B-52s and the pilots of the Khmer Republic who were dropping millions and millions of tons of bombs and of Agent Orange on Cambodia, would they look at the children who were beneath and who were being bombarded by them? In reality, Your Honors, it is not up to you. It's not to you that the prosecutors spoke these last days. They spoke to a popular jury. The popular jury, they believe, overrules you. They are banking on this horrible fact, what we call public opinion. The entire world has become a popular jury instead of you, Your Honors, and the prosecutors spoke to them over the past days. They did so because they are afraid. They know that there still exists, and again, a hope that you do your job as judges. There is always a hope. Whereas public opinion is easier to shock, and public opinion generally remains insensitive to issues of legal procedure. With a public opinion that is maybe not very well informed, we can please them easily. For example, it might give you headaches in the public that we have offered this terrible person to partake in hearings that had been announced previously as only destined to present key documents to the public and to the media in order to later on claim that these were part and parcel of an adversarial trial. Of course not. If maybe you do not even understand what I'm talking about, where is the problem? Maybe it prevents you from sleeping. Ladies and gentlemen in the public, that the scope of the trial of this horrible henchman has been modified during the trial itself with the addition of facts that were not supposed to be covered at the start? Why not? It might surprise you, ladies and gentlemen in the public, that neither this horrible monster who is behind me nor his lawyers have been able to read the prosecutor's closing brief in a language that they understand, that they master, in order to prepare their own statement properly, and that they were obliged to wait for the last minute, that is, say, the last days, to hear and understand the arguments of the prosecution? Of course not. Maybe it keeps you up at night, ladies and gentlemen in the public, that in August 2013, whereas the hearings were already finished, and that the Chamber added to the case 1,399 written statements 4 weeks before we filed our final briefs? I'm sorry? No. Does it scare you, ladies and gentlemen in the public, that this horrible person has regularly seen his right to legal safeguards violated, his right to be informed of the charges against him, his right to have time and to have the necessary means to prepare his defense, his right to an equality of arms with the prosecution? No. And finally, does it terrify you, ladies and gentlemen in the public, that the counsel of this horrible dictator, bloodthirsty dictator, will never have had the time to speak about the probative value of the thousands of documents that make up the current case file, and that the judges will rely on to convict him? Come on. Let's get real. This gospel has been said. You may proceed. There's nothing to see. The prosecutors may acknowledge in their submission of August 2013 that the trial chamber did not hear all of the evidence relative to the policies of the CPK, which are not the object of the current trial, while referring abundantly to these same policies in order to plead the existence of a common criminal purpose and the existence of a widespread attack and systematic attack targeted against the totality of the Cambodian population. Nobody will see anything in this. The prosecutors are banking on the fact that the entire world doesn't care at all about the conditions in which this trial is taking place. In November 2011, during the first hearings, your chamber had authorized the prosecutors to open their statements on the totality of the closing order. And those who only attended these first days in November 2011, and then 2 years later, a few days ago, who attended the prosecutor's statements, will be convinced that what is being tried here for the past 2 years is the totality of the closing order. It is the trial of the Khmer Rouge and of Democratic Kampuchea, and this will be broadcast in the media, and they will speak about the 2 million deaths and the 3 years, 8 months, and 20 days of the regime. And the prosecutors are banking on the fact that when Mr. Kyosompon will be convicted, we will repaint once again the buildings of this court. We will dress up again this court, and we will mow the lawn, and we will see outside of the building cars line up, the cars of the ambassadors of the countries who financed this show in what we should call here a theater, because this building is a theater. These beautiful diplomats and these beautiful ladies who did not follow, who are not at all interested in this trial and in the difficulties that we're facing for one instant. These international journalists that we have barely seen over the past 2 years.
President, Council, we have reminded you before that your statements are not directed to any particular individual. What you have raised clearly does not involve in the facts adjudicated before this court. So please make sure your statement is respectful to the chamber and to the parties and the public, in particular in respect of the code of conduct for lawyers. And your closing statements are directly related to the facts and the applicable law within the scope of this trial. In particular, with the focus on the facts that have been severed from the main facts in case 002. So make sure your closing statement related to the adjudicated facts, and try not to use this time to attack other people or to attack the chamber or the court. This is the second reminder to you, Council. And of course, we do hope that you would adhere to the instruction by the chamber.
Well, probably we don't have the same concept of what a final statement is, Mr. President. I don't believe I offended anyone here by defending my clients before you, nor have I insulted anyone. Lawyers are free. This is a moment of freedom. This is a moment where the defense may express itself without being limited or threatened and being criticized for having violated whatever kind of rule I have not violated. So no matter what, I was saying that the people who only attended the first days of this trial and then the last day of this trial will have the impression maybe that this is the trial of the century and that the trial of the century did take place. But in reality, it is not this trial that took place over the past 2 years. And therefore, the truth is, Mr. President, is that at the end of this trial, we believe that either you will abide by the law and acquit our client, or you will sentence him, and we believe there will be a violation of the basic principles of criminal law. Mr. President, for us, I don't believe we're insulting anyone. There is no halfway. And you will not be able to say either that this situation is the result of a strategy from the defense, because it is you and you alone who took this decision to sever the case. We had no say in this. There is no specific tactics from the defense behind this. When my colleague Kopper pleaded and you did not interrupt him then, he said a few days ago that he was hoping that the international judges would constitute barriers, strong barriers, And I would like to say that regarding this, I do not necessarily have the same opinion. I believe that the Cambodian judges can do just as good a job as the international judges. I trust you as much as the others. In fact, I trust your chamber, no matter the way it's made up. And as far as the Cambodian judges are concerned, I would say, this is your country. This is your justice. This is your reputation at stake. One day, maybe in the near future, the authoritarian and corrupt regime in this country will apparently have to accept its defeat. A new era might begin. And we also have to prepare ourselves for this era. And you, Cambodian magistrates, may be among those who will start this revolution. Those who will say to the international community that, okay, thank you very much. You have...
President, I think your statement is out of the scope of this trial. So make sure that your statement is related to the facts adjudicated before this chamber and as part of the closing order. You should have noticed how other parties presented their closing statements. Their statements are related to the facts before this court. And for that reason, the chamber did not interrupt any of the previous parties. You cannot compare this chamber to a theater, and that you could wrest facts out of the scope of this trial. The scope of the trials is based on the facts determined to be adjudicated before this chamber. And of course, the chamber will consider all the relevant facts, evidence, and applicable law related to the proceedings in case 002/01. And of course, the scope for that trial has been already set, and you are well aware of that.
Yes, of course, I'm well aware of this, Mr. President. And this is why I started by reading your decision again at the beginning of my statement, your decision of October 2012. And I'm also aware that the prosecutors are trying in their submissions to encourage you not to respect this decision that you took in October 2012. And therefore, this is why, while anticipating the possibility that you are seduced by the proposals made by the prosecution, that despite your assertion that the scope of this trial had been defined and it would be respected, this is why I'm taking the liberty of pleading this point. If you had allowed the prosecutors to express themselves and plead points that are outside of the scope of this trial, why, therefore, should I now not be allowed to answer to them? What kind of justice is this? What kind of justice authorizes the prosecutor to say any old thing and prevents the defenders from condemning this situation? That is exactly what I'm trying to do now. This is exactly the aim of my statement. And this statement seems to me to be even more so important that we have, as we have developed in our closing brief, and we have developed our points in a submission that we filed before the Supreme Court, a submission entitled request to stay the proceedings immediately and a request to release Kisompon immediately, we have believed that there exists for us on the defense side reasons to fear that indeed your chamber might be seduced by the reasoning proposed to it over the past days by the prosecution, and that indeed your chamber may ready itself to use facts outside of the current scope of the trial to sentence our clients. I want to speak here about the series of decisions in which you indicated often that if it was possible to speak about the existence of the totality of the policies of democratic Kampuchea, we could not speak about their implementation. And this is why I spent an hour of my time trying to understand the message that the prosecutors tried to pass on to you. And this is why I spent an hour of my time explaining to you that when one submits that Cambodia was transformed into a nation of slaves, well, that means necessarily that we're speaking about something else than population movements and 1 week at Tulpul Shrey. It means that they are pleading the entirety of the closing order. They are asking you to rely on facts that were not covered by this trial. And when your chamber states in various decisions that we may consider discussing the existence of the 5 policies, my duty as a defense lawyer, my duty as a lawyer is to condemn not only the proposal made to you by the prosecution, but also what may suggest, what they may suggest as a future decision on the part of your chamber. Of course, this might resemble a trial of intents, and this is why I have also mentioned the recent decision of the Supreme Court, which answered to us after 3 months in a 2.5-page document that our statements were very worthy, but it would be necessary to wait for the decision of the chamber, and if things were not satisfactory to us, we could lodge an appeal against your decision. I know this very clearly, but my work is nonetheless to condemn something that is developing before you, something that is proposed to you in an extremely convincing way, I must admit, and in an efficient way by the prosecution. It is, in a few words, the whole show behind this trial, if we can speak about a show without being inappropriate, because the stakes are very, very high. And this is everything. This is all that I tried to do. I see that it's 10:30. I was going to speak now about the question of the evidence. This is another topic, so I suggest that we take the break now.
President, thank you, Council. The time is appropriate for a short break. We will take a 20-minute break and return at 10 to 11 in order to resume our proceeding. The court is now in recess.